I would like to express our gratitude for the great discussion we certainly had, and to all of our speakers, and also to the moderators for coordinating those discussions that have been so interesting ones. My task is just to deliver a very short speech. I was instructed not to be more than 15 minutes, so I wouldn't exceed that period of time, but to give a kind of closing remarks for this afternoon of today. And I would like to use this opportunity also to reflect upon the issues that were touched upon today, and also to identify a couple of key points for that. I think that it seems to be a very clear demand that there should be some kind of regulation, but I also do think that to have a proper regulation requires something more than perhaps we would think, because I think there is a need of a kind of innovation, because I think that the problems we want to address, at least from a methodological point of view, are something new that we didn't face so far. So perhaps the old patterns of regulation that we want to have something in the law and we want to have rules and the rules are enforced and the question is who would enforce them doesn't work, it simply wouldn't work anymore, at least not in this area. It was also a question whether we need a national or an international reaction of that, and I think that that there's no other way to do that than the national law, because even we would be very happy to have an international law, or at least a European law, to say what to do with that. I don't think it's possible due to the differences amongst the societies. That's not simply a cultural difference, it's also a difference how, I don't know, simply social media is used in different societies. There are very different patterns for causing different problems and calling for different reactions from the legislator. So I would be very skeptical to wait for even a European answer. Also, there is a great bulk of European legislation at the moment. Just we are facing new acts, regulation, directives are coming. But if we go to the heart of the problems we discussed, we don't see there is a solution in that. So I think there are not only rules, not only norms in these European products of legislation, but there are also very big gaps. And even there are some contradictions caused, which doesn't really help for us to solve the most direct problems. I simply want to mention one, that there are responsibility issues addressed, but there are no liability issues addressed at all in European law. I mean, know the consequences, what if someone failed to comply with that. It's very interesting, I think, that we don't discuss about the results. I think if we would get a question, what kind of society do we see as an ideal society and what should be the result in the society or what shouldn't be the result in the society of the conduct of those operators we are addressing, I don't think there would be a big discussion. I think mostly we would like to see the very same thing or at least the very similar things. I don't know, no privacy violated, data should be protected, there are no lies to be seen in the news and so on. But the question is how could we reach that result? And that's why I think that the issue is some kind of methodological issue which requires a kind of innovation as well. I also do think that there are some very basic values of our societies are concerned in this whole thing, because I think the basic paradigm of a democratic society as well as a market economy is consent. And consent implies freedom, and vice versa. We are free in shaping our social interactions, undertaking obligations, entering transactions, and electing the decision makers of the society. But consent is free only if it was voluntary and informed. And that's why most of our discussions try to address or assesses the information, how information is provided to the citizens, how information is provided to the consumers, how the validity of the information is or should be guaranteed. And the problem is that the freedom to produce and to transmit and access information is certainly of a public interest. In the paradigm of law, the obligation to guarantee this freedom in vertical as well as in horizontal relationship is imposed on the state. This guarantee is basically provided by the freedom of speech and the measures that aim at preventing the transmitting incorrect and false information, which was the target of the media regulation that was discussed today in the afternoon. We have basically two options if we want to regulate something. The first option is the information model. According to the information model, if we can assume that if the proper information was provided to the citizen or the consumer, then she can pass his own resolution and to decide what to do or not to do. That's the information model. In the information model, there are no mandatory rules that the state doesn't want to say or the regulator doesn't want to say what to do. Simply wants to provide this voluntary and informed basis of the resolution. And we say it was this, then it was autonomous, and there is no problem with it, either as a citizen or as a consumer, because then it's a market decision, we would say. This is based on a duty of disclosure. A great part of the legislation, what we have now, tries to do that with transparency and explainability and so on. We want to think if I understand what happens to me, then I can decide if I want to do that or not. Still, perhaps, there is no voluntariness. That's another question, which also should be provided, and it's a question if it can be guaranteed in this sphere of the law. I think as to regulation is concerned, online service providers, in particular the gatekeepers we are focusing on in this conference, certainly don't stand above the law. They control channels of communication, accessibility of information for the members of the society, the flow of data, news, information, and they control also our choices as a citizen and as a consumer. They collect and process personal data and are very creative in introducing new mechanisms of influencing choices and social behavior. This also implies, that was also addressed today, that they undertake functions that societies normally allocate to the state. However, while we have very well-structured, very refined processes for controlling the state power in modern societies of democracy, we are much less experienced with controlling the power in the hands of the private companies. Private companies originally have been invented as vehicles for converting contractual relationships into structures of organization in order to make business more efficient and the economy also more efficient, but not for controlling social behavior. That's something very, very new that never happened so far. This is a big change because the gatekeeper companies are not simply to be seen as a target of regulation, but much more as part of the system of enforcement of law. In a way, they are not something we should target, they are the part of this whole system. If we are a bit more provocative, they are part almost of the system of the judicial power as well. They are not objects of social and legal processes, but actually are elements of them. Their role in controlling social behavior was described by a journalist of The Guardian as the following. I thought it could be interesting to quote her words because I think it expresses in very simple terms what happens. She wrote the following: think of Facebook as a bit like Ryanair or British Airways. If I get on a plane and the man sat next to me gets drunk and tries to grope me, I can file a police report when we land. But while we are in the air, my best bet is that the cabin crew and other passengers will deal with the problem. There are things that airlines can do to reduce the likelihood of that man behaving badly on a flight. There are rules that should be in place if he does. But Ryanair is not responsible for drunk and handyman, just as Facebook and Google aren't responsible for racism and terrorism. That were her words. I think another point in why regulation cannot be the very same as normally what we think, that mostly we are discussing in these contexts is about enforcement of fundamental rights. But the nature of fundamental rights is not only that they are described in a very broad term, but normally in these conflicts there are two conflicting fundamental rights, and that means that the interpretation and the enforcement of law doesn't occur in a traditional sense. But the problem is that there are two co-leading rights on two persons, very typically the freedom of speech and the right to privacy. And we have to decide, I mean, normally the court has to decide which one to get the priority. That means that in this sphere, it's always about evaluation because those norms express social values. In a way, we can say that law is about enforcing social values because the law converts social values into a binary code that's right or wrong. But it's true very much for this area of law. If we want to have some behavior banned by the operator, then what we expect from the operator is to make this evaluation. I think it just comes by facts. It's not about any kind of theory or approach or something like that. That's why I argue they are just a part of the system. And I think that if we are searching for the solution, and I think this should be the target of the discussions of the next decade or something like that, how to do that. I think we should accept that those companies have this role and function, which means they are the part of the system. If they are the part of the system, I think that it should be seen like a kind of privatization. We have some experiences with privatization. If statutory functions are privatized, then we have some experiences. Even a jail can be run by a private investor. And we don't have problems with how fundamental rights are to be protected in that jail. That's the very same as for a jail run by the state. We may have patterns for that. And for me, this is what we are discussing is very, very similar, something like that. If you say that those companies do something which we allocate to the state, we cannot take it from them. That's not the part of the solution, because the problem is that also the state wants to withdraw from many areas of life. The state doesn't want to be bigger in this sense. They are not in the position to take the opportunity to collect, process data, and so on. from these companies. But I think some kind of model of a public-private partnership should be at least considered in this sense. Even if you don't really like the idea, perhaps it would be more useful because it can result some success as well. This is something what is called in the legal literature, I like this phrase very much, that there is an invisible handshake that should be seen. So thank you very much for having the opportunity to close this afternoon session of this 2 days conference. And thank you very much again. I think also for the name of us, I mean from this side of the room, I can say many thanks for the organizers as well too, because I think they did a very, very good job with that. So thank you very much indeed again.